The best person to, quote, speak for a child, close quote, is the child himself or herself, not a guardian ad litem or private guardian ad litem. Maggie Kuhn said, quote, speak your mind even if your voice shakes. When you least expect it, someone may actually listen to what you have to say, close quote. And this is the minor child's free speech statement. I have my own voice and I choose my own words. No one knows or can express my experiences, observations, feelings, opinions, desires, and preferences more completely or more accurately than I. As long as I can speak for myself, I will speak for myself. I do not need, want, benefit from, or trust someone else to speak for me. I have a right to speak for myself without fear of punishment or shame. My words will certainly not be silenced, censored, or misstated through the perverse means of someone else being appointed, ostensibly, to speak for me secondhand. One of the worst ways, at least from a cost-benefit analysis, to discover what is in the best interest of a child at the center of a Utah child custody or parent time dispute is to silence the child's own voice through the appointment of a PGAL, or private guardian ad litem. One of the worst ironies about appointing a PGAL for a child is that while the PGAL is ostensibly the child's attorney, if the PGAL is incompetent or self-dealing, abusing the child's rights, lying, or otherwise misrepresenting the facts, whether by commission or omission, to the court, the child cannot bring this to the court's attention without doing so through the PGAL. If the child wants to fire the attorney or speak for himself instead of the PGAL doing the talking, the child is powerless to bring such matters to the court's attention because of the catch-22 way that the PGAL law is structured. A child represented by a PGAL is literally prohibited from speaking for himself or herself unless the PGAL allows it. Think about that. What kind of representation is that? Unless a child of at least average intelligence, maturity, and ability to communicate, and courage, who can speak for himself or herself, can make a case for having someone else speak for him or her, no such child should be denied the opportunity to testify, whether orally or by sworn statement, in his or her own voice, in his or her own words. PGALs do not have any particular expertise, resources, or knowledge, and certainly no judicial or other authority to determine a child's best interest. It is the province of the court to make that determination. The court cannot substitute its judgment for another's, which is why appointing a custody evaluator, or PGAL, is not merely unnecessary, it is arguably an unlawful delegation of judicial authority. The court, not the PGAL, determines the credibility of the witnesses and finds facts. A PGAL does not have that power. Reports and recommendations from a PGAL are so derivative, subjective, pseudoscientific, and unverifiable as to be nowhere near worth the expenditure of time, money, and effort that they entail compared to simply letting the children speak for themselves. Minor children can be interviewed by the court, resulting in far better evidence than a PGAL could ever provide. An interview by the court and/or by deposition, if the court wishes to avoid interviewing the children, provides the fact finder with the added benefits of A, the interview or deposition being on the record, and B, an interview by the court costs the parents nothing as opposed to the fees a PGAL charges. No one is better positioned or qualified to hear from the child directly and on the record than the commissioner and/or judge assigned to the case. This is more than reason enough as to why the court can and should interview minor children. Many cite Utah Code Section 81-9-204 sub 5, formerly Section 30-3-10-7, for the proposition that a child cannot be interviewed without parental consent. This is not true, or unless the court finds that an interview with a child is the only method to ascertain the child's desires regarding custody. That's a quote out of the code. This is patently false. 81-9-204-5A provides that, quote, a minor child may not be required by either party to testify unless the trier of fact determines that extenuating circumstances exist that would necessitate the testimony of the child be heard, and there is no other reasonable method to present the child's testimony, close quote. 81-9-204-5A does not bar a commissioner or judge from interviewing a child of the court's own accord. To know what a child has experienced, observed, and felt requires inquiring with the child on the record, not with someone else who claims to have inquired with the child, but made no record of the alleged inquiry and the child's responses, and instead provides a subjective, summary, unverifiable, indirect account. Section 81-9-2045C3 provides only that, quote, the prior consent of the parties may be obtained but is not necessary if the court finds that an interview with a child is the only method to ascertain the child's desires regarding custody, close quote, emphasis added. 81-9-2045C2 thus does not prevent the court from interviewing a child to ascertain relevant facts, other than the child's desires regarding custody, bearing upon the child custody and parent time orders. Moreover, petitioner's counsel or a respondent's counsel cannot find any case law that construes what the only method to ascertain the child's desires regarding custody means. It suggests that clearly the best method, meaning the most accurate, expeditious, and inexpensive way to ascertain the child's desires regarding custody is by having the court interview the children on the record. Thus, nobody knows why or how a court would want to try to ascertain or could justify trying to ascertain a child's desires by any one or more inferior methods. Clearly and logically, the only method, language of 81-9-2045C2, was not meant to condone inferior evidence-gathering methods when the value of such methods is not plainly offset by countervailing interests, and stronger countervailing interests. Aside from its lack of substantive evidential value, which is no small defect, a PGAL does not justify his or her costs. Moreover, a PGAL's unrecorded, unverifiable second-hand account of what a child allegedly said and or did not say is utterly and unnecessary and unjustified. A PGAL is patently not needed or warranted when the court can hear from the parties' children directly, in each child's own voice and in his or her own words and on the record. At the very least, the child's testimony of his or her experiences, observations, feelings, opinions, and desires should be obtained by a court interview conducted on the record before the court should contemplate appointing a PGAL. While I am of the considered opinion that a PGAL is rarely, if ever, a good idea when a child is sufficiently intelligent, mature, lucid, and articulate enough to testify in his or her own words, appointment of a PGAL should never be ordered without the court first interviewing a child and determining whether a PGAL is needed and why a PGAL is needed.